Hello everyone, my name is Shagun Payasi. Together with my teammate Kinjal Raghav, we will be presenting on a landmark case, Rothwell versus Chemical and Insulating Company Limited, 2008, a key decision of a House of Lords in an area of tort law. This case is particularly significant because it clarified what counts as actionable damage in negligence. In other words, it answered an important question: when does harm become serious enough to be recognized by the law? In today's representation, we will begin by explaining the facts of the case and the legal issues that come before the court. Then Kinjal will go through the judgment principles established and the conclusion summarizing the case importance. So the facts of the cases are: the claimants in this case were workers employed by the chemical and insulating company. During their employment, they were regularly exposed to asbestos, a toxic substance commonly used in insulation material at that time. As a result of this exposure, they developed what are called pleural plaques. Pleural plaques are small, localized area of thickened tissue that form on the lining of the lungs. The crucial point, however, is that the pleural plaques are symptomless. They do not cause pain, they do not impair lung function, and do not make breathing difficult. In other words, they are physical change inside the body, but they cause no actual harm or disability. Despite being harmless, pleural plaques are medically significant because they serve as evidence of past asbestos exposure, as they indicate a higher risk of developing serious diseases in the future, such as asbestosis. Because of this, the claimant brought negligence claims against the employer. They made three main arguments. First, that the pleural plaques themselves should be treated as actionable physical damage since they alter the body's tissues. Second, that the risk of developing serious illness in the future should be compensable. Third, and that the fear and the anxiety of potentially developing such illness should give rise to damages as well. Essentially, they were saying even though they weren't sick yet, they had suffered harm in other ways, physically through the plaques and emotionally through the worry of the future diseases. So the issues before the court, this led the House of Lords to consider several important legal questions. Do symptomless plaque amount to actionable damage in negligence? Does an increased risk of future illness count as actionable damage? Can fear of anxiety or of future illness be compensated? And finally, can plague risk and anxiety be combined to create a valid cause of action? These questions force the court to draw a clear line between the actual damage and potential or psychological harm. The key issue was whether mere risk of future harm or the risk of that or the fear of that risk was enough to trigger liability in negligence.
Judgment. The Court of Appeal had already dismissed the claimant's cases, and the House of Lords upheld the decision in 2008. The Lord concluded that none of the claimant's arguments succeed because they had not suffered any actionable damage. Their reasoning can be summarized in 4 points. First, the House of Lords held that plural plague do not amount to actionable damage even though they show a physical change in the body. They cause no symptom, pain, or disability. The law requires more than just a physical alteration. There must be a real, demonstrable injury or impairment. Second, the court ruled that an increased risk of developing a future illness is not actionable in negligence. In tort law, there must be a present harm. The mere possibility of future harm, however likely or frightening, is not enough on legal grounds. Third, the law decided that fear or anxiety of future illness is not compensable unless it results in a recognized psychiatric illness. In other words, simply being worried or distressed about a potential disease without developing a medical condition like depression or anxiety disorder is sufficient for damages. Fourth, the court emphasized that non actionable harms cannot be combined to create actionable damages. The claimants had argued that while each element on its own might not be enough, together, plague, risk, and fear, they form a complete picture of harm. The Lord firmly rejects the idea, famously stating North versus North equals North. Principle established. This decision established several lasting principles in tort law. Actionable damage requires real demonstrable injury, not just physical changes that have no symptoms or effects. Risk and fear alone are not sufficient to establish negligence, there must be actual harm. Non actionable harms cannot be combined to create liability, or even multiple minor or hypothetical harm do not amount to real damage. Fourth, the case also reinforced that courts' concern about opening floodgates to endless claim where no genuine harm exists, allowing such claims could lead to overwhelming liability for employers even when no one has actually been injured. This judgment therefore drew a firm boundary in tort law between potential harm and actual and compensable harm. To conclude, the Rothwell versus Chemical Insulating Company in 2008 case was a defining moment in clarifying what constitutes actionable damage in negligence. The House of Lords made it clear that claimants cannot recover damages simply for risk or worry or asymptomatic physical changes. There must be genuine injury. This case serves as an important reminder of the balance that law must maintain, on one hand ensuring the victims of one real harm are compensated, and the other preventing an unmanageable expansion of liability where no actual damage exists. That concludes our presentation on Rothwell versus Chemical and Insulating Company 2008. Thank you for listening.